All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in LH and DL versus Vandenberg, City of Peoria, Real Party and Interest. Our cause number 1CASA230055. Council, we've read the briefs in this matter. We've discussed it at conference this morning. Both sides are entitled to 20 minutes to present their arguments. It's my understanding that the city will cede 5 minutes of their time to the criminal defendant. And with that, when you approach the podium, if you would please state your name and the party for whom you represent, and we will begin.
Good morning, Your Honors. Jamie Bolson on behalf of LH and DL petitioners in this matter. May it please the court. A trial court has jurisdiction to hear a victim's motion to seek enforcement of their right to receive a copy of the police report. This is clearly set forth in 134437, which states the victim has standing to seek an order in a trial court seeking to enforce any right or challenge any order denying any right guaranteed to victims. And this has been reinforced through the court through Padilla. In the spirit and intent of the victims' rights laws, 134437 must be read in tandem with 39127, along with the plain language of 39121.02 and its use of the permissive may. This follows from J.D. v. Heggie, which says when interpreting a statute, a court's primary goal is to give effect to the legislative intent. And Haag v. Steinle went even further. If there is an uncertainty about a statute's meaning, we attempt to discern legislative intent by considering the statute's context, language, subject matter, historical background, effects and consequences, and spirit and purpose. That's 227 Ares 212.
Ms. Balser, is there anything that would prohibit the victims from simply requesting the police report from the county attorney's office?
They won't give it to us. Your Honor,
Is there anything in the record that would support that? I mean, did you make that representation, and could you simply ask the court in the criminal matter to order the county attorney to provide it?
In this case, Your Honor, I did not make that request. I've handled hundreds of cases with the Maricopa County Attorney's Office, and I've made the request on numerous occasions, and they always say the same thing: go get it through the police department. We're not comfortable releasing it. So I didn't in this case just because my history with them has demonstrated to me it would not have happened.
So you did not ask the county for it, or did not seek an order requesting the county attorney provide it to you?
That is correct, Your Honor. And the second part of your question is, could I seek an order to obtain that? I don't think I'd win. I think the language in 39127 that says it's the police department or the law enforcement agency, I believe is the language, would require the court to say, I can't compel the prosecution to give it to you. You have no right to discovery as non-parties to the case.
Is the term law enforcement agency defined somewhere?
Because I
don't think it is. So I'm just wondering how the county could argue it's not a law enforcement agency.
Not that I recall. It's been interpreted to mean police departments. I've never had a case where that's been interpreted.
An opinion that has said that? Because I would be shocked to find out that the county attorney's offices around the state are not law enforcement agencies.
And I was referring to the county attorney having the requirement to comply with 39127. The interpretation I've always encountered and experienced was that 39127 meant the request was made through the police department and that the fulfillment of that request was through the police department.
So if the city attorney's office was prosecuting the case, Yeah, I guess, have you ever made a request to the city attorney's office, and do they take the same position, that we're not the law enforcement agency, these guys down the hall at the police department are instead?
It is always, you must go request it properly through the police department. We know the legislator's intent with the victims' rights laws is in part to decrease the trauma victims go through when interacting with the criminal justice system, to aid in the healing of the ordeals, was the language used. And from Farley, where Arizona's Supreme Court said statutes must be interpreted with other statutes so that they are harmonious and consistent, even where the statutes enacted at different times contain no reference one to the other, and it is immaterial that they are found in different chapters of the revised statutes. Yet this is one of the refrains we saw over and over in Peoria's brief, that somehow the age of the victims' rights provision is determinative, or that because some of the provisions in the public records chapter, and not directly in the victims' rights chapter, that is determinative, or because the Victims' Bill of Rights or Victims' Rights Implementation Act doesn't specifically reference the public records law, that is determinative. Neither our courts nor our legislature intended such a narrow view of the victims' rights laws.
Does the public records law conflict with the victims' rights laws?
In regards to this issue, no, I don't think it does. 134437 says that victims can obtain an order to assert any right. And here the statute 39127 says that they have a right to a copy of the police report, a free copy of the police report. So I don't see that as conflicting. I see that as clarifying and complementing one another to ensure that the victims' rights are properly enforced.
I guess if we interpret the public records law in the way that the city would like us to interpret it, would that result in a conflict with the victims' rights statutes?
I'm sorry, I missed a part of your question.
Sure. If we were to interpret the public records law in the way that the city is asking us to interpret as being the exclusive avenue to obtain a copy of the police report, would that then result in a conflict with the victims' rights provisions saying that a victim has standing and can make a notice of appearance to enforce its rights under the Victims' Bill of Rights?
No, I don't think it conflicts with the public records laws, because ultimately there's two scenarios that can happen. The first scenario is that the request for the report can be made before the criminal case has started, and in that case it's a special action pursuant to 13121.02a. That's the remedy. But if the request for the report is made after the criminal case is initiated, it can be a special action, or the victim, pursuant to 134437, can file a motion in the trial court to enforce that right. So
the city is saying, no, you have to file a civil action in the form of you have to file a special action to get a copy of these. And I'm asking, doesn't that interpretation conflict with the rights that victims have under the Victims' Bill of Rights and the implementing statutes?
does Peoria's interpretation?
Yes.
Yes, it conflicts with it. The victims absolutely can go into a trial court and ask the court for help and for a remedy.
What about if assume that the city of Peoria had not intervened here? Then what? Would the court have the jurisdiction or legal authority or power, or however you want to call it, to order the police agency to disclose the report?
Absolutely, Your Honor. And
Under what authority? I mean, assuming that Peoria had not intervened.
Yeah, because under 134437, a victim can bring a violation of a victim's rights to the court via motion. So the court has the authority.
Yes, but at that point in time, the only parties before the court would be the prosecuting agency and the defense.
How would you serve the motion? You'd serve it on whom?
I've had this happen in other cases, Your
That doesn't
Honor.
mean it's correct. I'm just curious, what authority does a court have to order a non-party in an action to do anything?
Because of the way the victims' rights statutes and Constitution are written, they're supposed to be a floor, not a ceiling. They're supposed to be read expansively. If a victim has a right to bring a controversy in front of the trial court, a violation of the victim's rights, then the court must have the authority to remedy that. And I understand what Your Honor is saying, that it may not have been correct in the case I referenced. The court had the
Okay,
prosecuting
but
agency serve
I get
the
all
police
of that.
department.
The point being, a judge presiding over a matter has two parties before it. He or she can order either party to do it, to provide the request. But how can they order someone who is not in the courtroom to do anything? Isn't there a due process right to have that person be served and all of the other stuff that would go on in such a matter?
Well, the due process right here was completed. The city of Peoria had received
Our
notice.
hypothetical was the city has not intervened.
I'm sorry. So
The hypothetical that Judge Brown presented to you was the city has not intervened. So there's only the criminal defense and there's only the prosecution before the court. And my question is, isn't there a due process argument that in that scenario you couldn't order the city because they're not a party to the action?
Well, I disagree with you, Your Honor, just because of the nature of criminal cases. The police department is involved in the case from the very beginning. If, for instance,
So they are a law enforcement agency, everybody involved on that side of the aisle. On the prosecution side, everybody up and down the chain is part of the law, is a law enforcement agency.
I'm not sure I would quite go that far without a specific example, Your Honor. But my point is, courts do require police departments and order them to do things all the time throughout criminal cases.
No, they order the state to get the information from the police department, unless the police department is available and a party to the action. They'll order the state to get something from the police. They don't order the police because the police are not a party to the action.
Or at least that's how it should be. Is that what you're saying?
I see orders that are directed towards police departments in criminal cases, but nonetheless, Your Honor, the conclusion by Peoria that victims must seek enforcement of their rights.
So, walk me through then, correct or not, in other cases where this has happened and the city doesn't intervene, how has that worked? The court has ordered the prosecution to go and get the police report from?
To serve the police department that they need to have a representative appear and explain why they aren't turning over the police report. At that stage, it resolved. Then the police department provided the police report. So I've never had to argue it beyond that point. So moving to the requirement that victims would have to argue this in two forums. First, there's no prejudice to the city of Peoria, Defendant Ballestero, or MCAO by keeping this in the criminal court. Moving it just is a more expensive process for all involved. So just as criminal defendants are often disproportionately poor, crime victims predominantly are of limited means. So if victims are disproportionately poor and can't find free or low-cost assistance for other things like evictions or protective orders, how many could realistically initiate a new civil case to enforce their rights against the police department? And the same goes for defendants. If a defendant wanted to participate then in this issue and it was in the civil court, they would have to hire a civil attorney. For many, and I would even say for most defendants, that would not be able to do that financially. So such an outcome would result in two tiers of victims. Victims who can afford to get a lawyer and incur the expenses that go with a civil case, and victims that can't do that. That outcome of two tiers of victims doesn't comport with notions of fairness, dignity, and respect. The premise of requiring victims to enforce their rights in a second forum has already been rejected in regards to restitution. And enforcement of the victim's rights in trial court would reduce unnecessary use of judicial time and resources and preserve judicial economy. The trial court, being a superior court division with co-equal jurisdiction to the civil division, is in the unique position to address the issue. It's already informed of the facts and the law in the case, and likely could address the issue at one of the already scheduled hearings. And time is of the essence here. The criminal process doesn't stop when a civil suit is initiated. And the criminal court couldn't stay its proceedings to wait for the civil process to play out with running afoul of the defendant's speedy trial rights. In turn, this impacts a victim's constitutional right to a speedy trial, and it puts the victim in the position to have to choose their due process rights or a speedy trial. Peoria relies heavily on cases involving the exhaustion doctrine in support of its position that may is not permissive, but exhaustion doctrine cases are fundamentally different from what we have here. Those cases have administrative procedures, sometimes on several levels.
Could the Superior Court have just construed your motion to compel these documents as a request under the public records law for the police report?
Could they have construed?
I think this goes to your point that it's all one court. I mean, Maricopa has divided its judges up into criminal and civil, but really it's the Superior Court.
Yes.
So I'm wondering if it would have been possible for the judge here to say, I'm going to construe this both as a request under the victim's statutes and as a special action or request for public records under the civil statute.
Could the Superior Court have done that? Is your question? Yeah, I think they could have.
Yeah.
I don't know of any case law that would preclude a judge from observing a matter in front of it that it had jurisdiction to and resolving that matter. So I think so. The exhaustion doctrine cases have administrative procedures different from what we have here. Sometimes those administrative procedures are on several levels. It's no surprise then that in those cases, on those specific facts, that the litigants have to comply with the exhaustion doctrine before bringing the case in front of the court. There's a clear remedy for victims seeking to enforce any right or challenge any order denying any right, and they may properly seek relief in the trial court. Moving to whether crime victims have a right to a complete unredacted copy of the police report. By complete, we mean the original plus the supplements, which is authorized by 39-127 and 134405A31I. Unredacted means except for statutorily authorized redactions, like locating and identifying information under 134434E or personally identifying information as defined by 13123.01C.
For clarification, did you not receive the supplements?
I didn't
You
receive.
said you did not.
I did not receive any supplements, Your Honor.
Okay. How do you-
Supplements to the court's order?
No, so you said a complete copy of the report includes the
Oh,
original plus
I
supplements.
don't know if I have the supplements. We are
You-
still.
I mean, you don't know if there are supplements.
Fair, Your Honor. I don't know if there are, and I don't know if I've received them. My point is, by saying complete, that's
Okay.
what we were getting
Okay,
at.
thank
I
you.
apologize. The petitioners here are trying to figure out who the speaker is and what they said. We're not trying to get to anybody's personal information or anything that's inappropriate, but it has to be statutorily authorized. And there's no authorization to take out names of everyone and everything they said. Public records law requires transparency. The presumption is one favoring disclosure. The statutes and case law place a very high burden on governments because this is an area of great public importance to know what governments are up to. Here, neither Peoria nor MCAO's position comports with the statutes or the case law. It's their position that even if a police department redacts significant portions of a report, pages and pages, without any explanation or statutory support, that they've still complied with victims' rights.
So what are they entitled to redact?
Locating and identifying information, which is defined, and it's almost the same, almost exactly the same as personally identifying information. Dates of birth, social security numbers, home addresses, things that could cause harm to the people listed. A name can't cause harm. Having the person's name can't cause harm unless it's a confidential informant, but I don't want to get into things that we're not dealing with here. If the victim can't review what is in the report that she said or that others said, how can that be corrected with detectives or prosecutors? In here, LH and DL have consented to disclosure of all of their information, statements and otherwise, to their attorney, pursuant to 134434C3 and 13123.01A1. and Peoria still refuses to provide those portions to LH and DL. This doesn't comport with either due process or notions of fairness, and it certainly doesn't comport with the presumption favoring disclosure. Your Honors, I'm going to save the remainder of my time.
All right, thank you, counsel.
Saman Golistan for the City of Peoria. May it please the court. This is a case involving two separate rights and two separate remedies. Jurisdiction fails under Rule 1A here because petitioners need to follow the established due process that's found in the Public Records Statute that's available to every requester of public records, a civil appellate process via the Superior Court in Maricopa County. On the substance, petitioners also fail because they seek completely unredacted records, or at least they did in their briefs. That requires a wholesale rewrite of the public records law. It requires revealing victims' information to other victims, certainly not what the legislature could have intended. And it requires unwinding 40 years of this court's jurisprudence, essentially eliminating the Carlson balancing test overnight. Under Rule 1A of the Special Action Procedure, the special action shall not be available where there is an equally plain, speedy, or adequate remedy of appeal by law. In this case, that exists. The Public Records Title 39-12102. A person who has been denied access to records may appeal the denial through a special action in the Superior Court specifically. The use of may in this particular phrase has been found to be mandatory by the state Supreme Court, by this court, in many contexts.
Didn't all the cases, or at least most of the cases you've cited, refer specifically to the exhaustion of remedies doctrine?
That's right, Your Honor. Most of those cases were in the administrative context.
So how are they applicable here then?
So they're applicable here for two reasons. Number one, the reasoning of those cases dealt with the last step. We're not concerned with the actual administrative portion of this process. We're concerned with the appeal to the trial level part of the process, which is the final step. That part is analogous. The statute, this particular phrase exists 11 times in the Arizona Revised Statutes. And almost every time it's used in this way, and the courts have held that it may is mandatory in this context. A public records request essentially is the functional equivalent of, while it's not technically an administrative action, it's a functional equivalent. Somebody has to come, submit a request, that's an administrative action.
Aren't you missing the elephant in the room? There's no administrative agency involved.
That's correct. By its very nature, it's every administrative agency involved. The public records statute applies to.
They're not conducting a hearing. It's between the person seeking the record and the court. Nobody else.
So it's between the person seeking the record and the entity and the public records holder first, right? The request is submitted, then there have to be a denial, and then that denial comes to the court. So,
but why can't, to cut to the chase, why is a person limited to a specific remedy, if you will, a civil remedy, as opposed, because it's a unified court. There's only one Superior Court. Why can't the Superior Court wear two hats at the same time?
Well, in this particular case, the courts interpreting this particular phrase have said that it means this particular thing. The right is a pure creature of statute. The public records right exists only under statute, and the remedy is a pure creature of statute. Had there been any intention for that to be wider, the remedy to be wider, essentially for a court to wear two hats, that should exist somewhere in the statute.
Go ahead.
The court could have easily said must or shall instead of may. Well, not the court, the legislature. Aren't we supposed to, that's our first inquiry, is what language did the legislature use, and we apply it as normally written, as ordinary persons would understand it.
Right, that's right. For to the extent that plain meaning is the initial inquiry, that's correct.
Well, why move beyond that?
Well, in this case, we're not moving
just
beyond
because I realize there's decades-old case law that's done that, but why perpetuate the problem, or if you will, when we don't, this is not an administrative remedies case, and why wouldn't we just stop right there? After you said, an ordinary person on the street, if you ask him what may means, and you said, does may mean must, and most would probably say no.
The reason is it's not perpetuating a problem, it's solving a problem. The problem that it's solving is ensuring that there is a trial court reviewing this record, and a record is created. Here we are in a very peculiar mechanism arriving here, where the crime victims collaterally are pulling a non-party into a criminal matter where the record is actually clear.
Go ahead.
Right, I was going to say, they didn't pull you in, you
They didn't
moved to
you
intervene.
voluntarily did it.
Well, frankly, there was no choice. The city has,
What do you mean there's no choice? What were you afraid of? What was the city afraid of? Are you conceding the Superior Court could have issued an order and issued attorney's fees against you in the criminal case?
no, not against the city, no, but the city has a
What
right.
against who then?
Well,
I just don't understand the point. And then also you intervened on what grounds? What was the legal authority to intervene?
that's a good question. There's frankly not a clear legal authority. The root of the whole matter is without legal authority.
Well, and I think to Judge Brown's question, you moved under Rule of Civil Procedure 24.
That's correct.
Which to me is a tacit admission that the criminal court has jurisdiction both over criminal matters and to handle things that might be sort of civil in nature.
It's not a tacit admission. The court could have denied it. Frankly, it denied that it had jurisdiction over the issue and kicked it back to the civil court. I mean, that's the right answer.
You keep saying different courts. There's nothing about two courts.
Civil division, Your Honors.
Correct. Okay, so it says you may file a special action in the Superior Court.
Right.
Okay? If we treat their request for an unredacted copy as a special action in the Superior Court, aren't we there?
We're not entirely there. I mean, that's short-circuiting the process.
What process?
The process for public record holders, frankly.
They asked you for it, you denied it, you gave them a redacted copy, they challenged that in the Superior Court, and you intervened to make your point. Boy, it sure seems like it's the process, it has been incorporated.
Not entirely. I mean, in this particular case, there's information missing. There's data missing. We don't have a complete record. And I think focusing on the point that this process needs to be initiated in a civil process and not in a criminal context is what allows for that record to fully be created and for all parties to have that record and have this court review that record. This court is in a position to review, is being asked to review substance over which there is no record. And frankly,
You've said that the trial court didn't have jurisdiction, and there are different types of jurisdictional problems. There's lack of personal jurisdiction, lack of subject matter jurisdiction, lack of a cause of action, no standing. I'm trying to figure out which of those buckets your argument or your client's argument falls into.
I would say more than one of those. In this case, frankly, it's a subject matter question. I think it's also the procedural question, the last one that you mentioned in that list.
Standing?
It's a standing issue. I mean, this court in Reyes has said that remedies under procedural statutes and other statutes are not available to correct a violation of the public records. What principle the Peoria is seeking is a logical extension of that Reyes case. The Reyes has said those things cannot be intertwined, even in a civil context, even where a record holder was a party to that civil action. This is a logical extension of that, and the rights of the entities involved in this particular matter are even more attenuated than they were in Reyes. This court has said that separate treatments of those obligations, along with separate enforcement mechanisms, make sense.
So how is there not subject matter jurisdiction? Because the way I read the Arizona Constitution, the superior courts have broad subject matter jurisdiction over any case where exclusive jurisdiction is invested in another court. And I don't see the public records statute as doing that. So can you tell me where I'm wrong?
Frankly, it creates a problem of due process more so than a subject matter issue, and the process is not played out in full in the middle of a criminal matter, whereas
what process was your client entitled to that it didn't receive in this case?
Well, frankly, a full hearing, a full record,
But
those things
that
didn't
hasn't
happen.
happened yet, right? The court didn't even consider the merits of the, or am I wrong?
No, that's correct.
The court has not considered the merits of the motion to compel.
That's correct.
So aren't you, so, I mean, what's the basis for you to say that you won't get a hearing on that?
Well, the hearing has to be done in the proper form and the proper mechanism, and
In the Superior Court.
in the Superior Court. That's right.
And the last time I checked, Judge Vandenberg was a Superior Court judge, so she can hear the argument, all of the arguments, she can make whatever record she wants as it relates to the public records request.
She is a judge of the Superior Court.
And she can make all of those determinations as a duly appointed Superior Court judge.
She certainly can make those determinations.
And we don't need to have it in a civil case. We can simply have it in a case, which happens to be a criminal case.
Well, we do need to have it in a civil case. I mean, that's
Why? It's a unified bench.
That's what the statute says.
It does it say civil? Excuse me, does it say civil?
It
It says Superior Court, correct?
It does say Superior Court.
All right,
It says-
and we've just established that Judge Vandenberg is a Superior Court judge, and she has a Superior Court calendar, and she can make all of the rulings as a Superior Court judge.
She is a Superior Court judge. This particularly says special action in the Superior Court, which is not a criminal matter. The other issue that
Mr. Wilson, what
petitioners
if we take it out of Maricopa County and we were to put the same context in, say, Apache County, Navajo County, where they don't have departments? So you would have a judge who hears everything, and they're handling a criminal case. Why would that judge have to send it to another judge to determine? I mean, it seems like your whole argument is because Maricopa County has divisions, that it has to go to a particular division rather than going just to a Superior Court judge.
Not entirely. It's a question of the civil process versus the criminal process, and it's a question of conflating rights under the Victims' Bill of Rights and the Victims' Rights Statutes, and rights under the Public Records Law. The issue here that petitioners are claiming that crime victims can't follow the neutral due process that is found in the Public Records Law because that somehow violates their due process. 2 months ago, the Arizona District Court rejected a very similar claim. There, a criminal defendant, without availing himself to the due process of the Public Records Statute, sought to claim that he had a due process violation. The Arizona District Court said that the process that was due to him under the Public Records Statute was to file a special action, and his failure to seek that process doesn't give rise to a due process claim. That's really the heart of this issue.
Counsel, what's the citation for that case?
Citation, that's Houston v. County of Maricopa, and this is just fresh. That's CV 22-00875, 2023 WL 287-7617, page 6.
Thank you.
The legislature's right.
And what was the nature of that? What were the claims involved in that case? Was it a habeas case?
I'm not familiar with the intricate details of the underlying case, though actually in this case, the criminal defendant took issue with the publication of his birthday on the Arizona Department of Corrections website, saying that it violated his right to privacy. In this case, essentially a failure of the Carlson balancing test under the Public Records Statute. But he didn't bring a special action to challenge that. The court said that he has a due process. That process is under the Public Records Statute, and failure to follow that process cannot by itself create a separate due process claim where the remedy is open, the remedy is available. He chose not to take it.
Was he a criminal defendant, or was he a victim in an ongoing criminal proceeding?
I don't believe, I'm not entirely sure whether he was both a criminal defendant and a victim. I know sometimes those things can be juxtaposed depending on the situation. All I know is that he was a criminal defendant in an ongoing criminal
And if he wasn't a victim in an ongoing criminal proceedings, then he didn't have the statutory and constitutional rights that victims have in Arizona, right, at that point in time?
Right. So if he wasn't a victim, he wouldn't have the VBR. He would have due process rights, obviously, as a criminal defendant, but a separate set of...
And so if we think that the Victims' Bill of Rights or the victim statutes create a concurrent cause of action to allow a victim in a criminal proceeding to request copies of a police report That's a different situation than what was going on in that case in federal district court, right?
Well, similarly situated in the sense that there are the heart of the matter is that the civil process is open, and failure to use that civil process doesn't rise to the level of a due process violation. In this particular case, the due process allegation is under the VBR. In that particular case, it was a federal due process claim.
Counsel, I know your time is short, but could you address at least briefly the 134437 that gives the victims standing to seek an order to enforce any right that the victim might have?
Yes, the court says in State v. Hansen that the VBR is not unlimited, the legislative authority under the VBR is not unlimited, and that particular statute addresses rights, specifically enumerated rights.
Does it an enumerated right, the right to receive public records under the public records law?
It's not an enumerated right under the Victims' Bill of Rights. It's the same right under the public records law.
This statute only applies to the Victims' Bill of Rights?
The statute and
It says any right.
Any right, if you keep going.
Any right, or to challenge it in order denying any right guaranteed to victims.
Right guaranteed.
Your point is, and I'm trying to understand, your point is that that's limited to the Victims' Bill of Rights.
Right, any right guaranteed
You
to
didn't
victims.
say that in your response.
Is it your point that the police report provision is in Title 39 and not within Title 13?
That's correct.
Okay, but in Title 13-4405 says that the victim or the immediate family member of the victim, if the victim is killed or incapacitated, has the right to receive one copy of the police report, including any supplements to the report from the investigating law enforcement agency at no charge pursuant to 39-127.
That's right. So the key there is that last part, and this is going to be my final point, so I can allow Mr. Apfel some time. The key there is 39-127. If the right existed under the VBR, the legislature would have placed it under the VBR, and it would have referenced something in the VBR, the Victims' Rights Act.
Well, it does. It references 39-127 and says that the victim has a right to be informed of
That's right.
ability to get one free copy of the police report.
Under the public record statute, yes. And had it wanted to do so unredacted, it would have done so. It did so in Title 28. Had it wanted to have this be a Victims' Bill of Rights, it would have done so. It referenced the public rights record statute, which is a separate process. Thank you.
All right, thank you, counsel.
Good morning, Your Honor. Seth Apfel for Mr. Ballesteros. And I want to be brief. There's two main points that I want to make. First, very quickly to Judge Brown's question. I think the risk of having the same court consider both questions is that the case could devolve into a series of collateral litigation. For example, my colleague just completed a trial with 14 victims and multiple investigating agencies. So already bring all of those agencies and all of those victims, we could have a whole series of litigation not connected to the criminal case. And I think that is a legitimate concern. My client's concern in this matter, however, is something different that has not been discussed here so far. And that's the due process concern of the criminal case itself. Specifically, there's no question that due process rights of a defendant trump any rights of a victim. There's a ton of case law to that effect, whether you're talking about Roper or S.V. Thompson, whatever case you want to look at. Here, the concern about circumventing MCAO is that MCAO, or the prosecuting agency, is in a position to best determine what due process concerns may arise from providing the victims with unredacted reports. As an example, again, using that 14-victim case, if victim A is provided unredacted reports, including information about victim G, victim H, whatever other victims, then that's going to lead to cross-examination and impeachment. Well, didn't you learn this from this victim's report? And so on and so forth. So our concern is the tainting of the criminal case and the witnesses involved.
Would the Superior Court, a different judge in a special action filed appropriately under the city's view, how would that be any different? How would that judge have any ability to handle that better than the criminal judge who's very acutely aware of what's going on in the case?
I'm not suggesting that a different judge is necessary.
Wouldn't your client have to potentially seek to intervene?
Well,
In the civil case? The
I'm
public
not,
records case?
I'm certainly not suggesting that a different judge is necessary. Certainly, the same judge is capable of handling it.
That's not going to happen in Maricopa County. Isn't that kind of pie in the sky, thinking that a public records lawsuit would be assigned to this judge presiding over this case, Judge Vandenberg?
Perhaps, but I think the underarching issue is the due process concern. And I think by utilizing the public records statutes and going straight to Peoria and trying to litigate this issue against the city of Peoria, while circumventing the prosecutorial agency, the city of Peoria is not in a position to determine what information will and will not impact the due process concerns of the criminal case. And I do see I'm out of time. If you want me to complete my answer, I certainly can.
All right, thank you, counsel.
Thank you, Your Honor.
Ms. Paulson, any final word?
Just briefly, Judge. Your Honor, Mr. Atfel mentioned that this could devolve into multiple litigations because in the State v. Ordway case that he is referencing, there are 13 or 14 victims. He misses an important point. There's one police department. And there's a way around what he suggested. His argument is disingenuous, saying if victim A requests the report, then you have all the other victims who you might get that information. Here we specifically are saying, if you feel like you need to keep that information, our attorney is consenting to getting all of our information for victims L, H, and DL. But Peoria didn't say, you know what, you're right, they've consented, we'll give it to you. They said, no, you're not getting it. So his argument is disingenuous. Your Honors, the statutes have to be read in tandem. The victims' rights provisions are supposed to be expansive. They're supposed to protect victims. As the Fay case said, victims' rights are a floor, not a ceiling. And this court has the authorization to order that 1344-37 applies and that the Superior Court can handle this matter.
All right, thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course. With that, we're in recess.